Hello, and welcome to the Prime Legal Services Quiet Title Action webinar. This won't be long. It'll be a short educational seminar on how preemptive foreclosure offense can help you and your client. If you have any questions along the way, feel free to either type them into the chat box that you'll find in the bottom right of the screen, or you can write them down and we will unlock all the microphones after the webinar and they can be asked then. A couple of the topics that we'll be touching on today will be why we choose quiet title action, mortgage securitization and how we got to where we are today, how to approach a quiet title, and also the possible outcomes of quiet title action. Before we get started, it's very important for us to explain to everyone viewing the presentation that this is for informal purposes only and should not be considered legal advice. We are not a law firm and we do not employ lawyers and cannot offer any legal advice. We strongly urge each of our prospective customers to consult with an attorney regarding any questions or concerns relating their mortgage. So let's get started. A lot of people ask us, what is a quiet title action? And the best way to explain that is a quiet title action is any action used to invalidate your mortgage or nullify the deed of trust and secure the mortgage. And you do that based on trust laws and what's not recorded in the land record. Here what we're doing is we're looking for improper assignments and various transactions of the note, then proving that the foreclosing party has no standing based on the improper transactions. And of course, you know, in our industry, litigation climate changes on a yearly basis. Even sometimes every 3 months, we have to rethink our approach, not only to quiet title action, but to litigation as well as out-of-court negotiations as well. You know, judges are becoming much more educated, finally, on the happenings in the foreclosure arena. And so Rocket Docket is done, and you know, these affidavits and assignments that were taken at face value are now looked at much more carefully. And you know, things like seeing a MIN number and having MERS on your mortgage, blatant robo-signers, you know, known robo-signers, as well as other fraudulent documentation and unrecorded assignments are leading the way for judges to, you know, really look at these foreclosure cases and not just hand them out as if they were owed to the banks like that happened so many years before. So now that the courts are viewing evidence much differently, foreclosure defense of yesterday has become today's foreclosure offense. Instead of going in there on the defensive and having to prove that these assignments did not come from you, having to prove there was paperwork that you didn't sign, having to prove you know, that maybe some back payments were made. Instead, the judges are more understanding, and you coming to them preemptively and saying that you found these various signs of fraud ahead of time. And that's why homeowners are winning quiet title actions. And not only that, but the attorneys are getting much, much better at litigating these cases. Fortunately enough, the approach is simple and the outcome is powerful. You know, all the evidence is right there for you in a level 3 Bloomberg audit. The thing you have to do is you have to get a specialized Bloomberg audit and have a trained foreclosure defense attorney look at that paperwork and file it the correct way. When all those things are done, it's really it's a very, very strong standing. Now, of course, these attorneys got to where they are because of the laws of yesterday. So when we look at securitization, you know, this is really why we're here doing these quiet title actions. You know, back in the day, you had a mortgage that was, you know, essentially sold to another mortgage or, you know, another lender, and the promise there was that it would be paid back in full. When you start taking these mortgages and selling them off to investors, there becomes some bigger issues because the investors need something back on top of that. So you can see here, when an originator sells a loan and the consumer's note and the mortgage are created, the financial institutions pool these loans together. And when you're pulling these loans together, you're then going to be splitting the mortgage and the note when a trust is created. And at that point, the trust then owns those and manages those mortgages together. Unfortunately, the trust represents the interest of the investors who buy those certificates in the trust, and often these are the people that have the problems with their investments. These investments are largely underwater and are not returning what they were promised that they will return. So instead of trying to make the note come up to production and get the homeowner paying on an affordable payment, they would much rather foreclose and liquidate at market value and eliminate these bad investments rather than keep them in their portfolios. So after all this transferring of the note, obviously there was a major loss in value, and that actually was caused by transferring the note so many times. And these trusts were created under New York laws, which had very specific acceptance and transfer requirements for the mortgage notes. These mortgage notes not only had to be recorded when they were transferred, but also paid for the transfer at the county clerk's office. And a lot of times you'll see different cases of different states suing MERS for back transfer fees. And these are common litigations that are popping up around the country. Now, of course, MERS essentially created this problem by being a system that was supposed to take care of knowing who and where your note was transferred to. Each one of these loans got a MIN number and was transferred into the system. However, the transfer requirements that were mandated by the New York trust laws and the local state laws were intentionally ignored and broken to save money, as well as confuse investors as to whether it was how many people owned their mortgage or the value of the actual investment. So real quick, before we get into the quiet title approaches, we just want to touch up on some terms so that everyone's on the same level. It'll be good to get a better understanding of these. So when we talk about quiet title and we mention the deed of trust, this is where the legal title of the property is transferred to. And they hold it as a security for a loan between the borrower and the lender. The note itself, that's the promissory note to pay back the mortgage. And that's generally used as a collateral instrument for no obligation. The trustee, this is the party that has the ability to foreclose on the lender, but would have to agree to the foreclosure with the lender, and also would have to wait until the homeowner is in default. And then the lender, being the party that actually lent the money and has the financial interest in the transaction. What they can do is they can instead substitute in a trustee in order to foreclose when the other trustee would not like to. So then we get down to substitute trustee. Again, these are placed onto the land record by the lender. And when they do that so that they can have a trustee with the supposed legal right to foreclose, even if they were not placed on the land record in the correct way. And then lastly is MERS, the Mortgage Electronic Registration System. This was the system created by the mortgage lenders, designed to prevent anyone from really knowing who the lender is, and also allowing all of the lenders to avoid the local recording fees that we spoke about earlier in the clerk's offices. So when we decide that we want to move forward with a quiet title action, we have to take two approaches. The first approach comes from coming in at a very early stage. And what we do here is we could essentially attack the original trustees of the mortgage and demand that they remove themselves and have no relationship with the fiduciary duty to the current lender. Now, if we do file the case against the trustee and the mortgage, it would only be against those listed in the land record. And many of these go unopposed. The original trustee and the mortgage don't answer to the actual judgment. Now, the second approach that we would take would be if the lender had already put a substitute trustee into the land record. If that's the case, what we would do is we would approach the disclosed lender and essentially challenge them to prove ownership of the note. A lot of times through that we're going to find the invalid assignments and transfers and essentially get down to the brass tacks of that they have no right to enter a substitute trustee into the land record, which can generally be stronger than a show the note case. Of course, the other great part about all this is that burden of proof in trust laws is higher than that of contract laws. Also, the New York trust laws are very old and extremely clear in what they state. And what this does is it forces the party to prove that they have a standing to actually foreclose on the property. So what we could do now is we could take a look at some quiet title actions that have taken place over the previous years. The first one that we have here is U.S. Bank versus Antonio Ibnez. Second sentence stating, to be the holder of the mortgage, one must be the original mortgagee or assignee under a valid assignment of the mortgage. It's not sufficient to possess the mortgager's promissory note. And then if you scroll down a little bit more, it says this without more is sufficient grounds on which to invalidate the foreclosures, and land court was correct to do so. So here's a case where homeowner's home was saved from foreclosure. The next one being Phyllis Horace versus LaSalle Bank. What we see here is pretty much the same case, no standing, and if you look at the bottom from the plaintiff's motion for summary of judgment, it states that the failure to show the proper chain of endorsements and the assignments contained herein, and then if you scroll down here, they ever were or ever could be the holder of the mortgage promissory note. Okay, so another case where you're seeing improper assignments and the improper filings of transferring the mortgage note, and even though they can prove that they may have the promissory note, is not legal standing to foreclose on the client's home. So before I pass you off to my colleagues, in closing, the components of a successful quiet title action, like I said before, it's best if filed prior to the substitution of trustees, and to prove the chain of title defects, we will have the securitization audit specially done on a Bloomberg level 3 level, get those pooling and servicing agreements so that we can prove the assignments were incorrect. Now, if we have to file against the substitute trustee in the current mortgage, we'll reference the New York trust laws, and we'll attack the validity of all post-closing assignments. We will also request that the trust be permanently enjoined from foreclosing and for the mortgage to be declared null and void.
This is Fuquan Bilal with Prime Legal Services. I'm one of the certified mortgage auditors here, and I'm here today to discuss the Bloomberg audit. The Bloomberg securitization audit is the key component when an attorney is filing a quiet title action. The audit, the comprehensive detailed report, will have information such as how many classes the loan traded in, if the credit default swap was paid to the lender already when the loan triggered in default. It also will give the attorney the ammunition they need to successfully win their case. It will show if the assignments that were done in the securitization process were done properly. It also will show if a 15D was filed, if the trust filed that the business, they're no longer reporting to the SEC. It will show the birth date, the cutoff date, the closing date, and who the transaction participants are and the securitization participants are. The Bloomberg audit is a more in-depth audit than the securitization audit because, again, it will state the New York trust law, which all of these lenders had to adhere to, the policies and procedures of the New York trust law. It will show the pool and the service agreement. It would also show the 4.1, the exhibit, which is the conveyance of mortgages, how the mortgages are conveyed, and the rules that the lenders are supposed to follow. It will also show the assignment of mortgages and the rules that they were supposed to follow within this assignment of mortgages. The audit also comes with a summary which explains the amount of notes that were pulled together. It also will show that specific loan number by zip code. A lot of times when we do the level 2 audit, the standard securitization audit, it shows that this loan is possibly in this pool of mortgage, this pool of notes that's within this trust. The Bloomberg audit is more in depth because it will show the exact loan number and a zip code. So if an attorney on the opposing side for the bank say, how do you know this note is in this trust? The Bloomberg snap screenshots will show by loan number and by zip code, loan amount, date of origination, the type of the loan, the interest rate. It would show all that specific data that will prove that the note was securitized, that it was traded and sold in different classes, and that the credit default swap was paid. And that's great for an attorney who's filing quiet title. Prime Legal Services, we specialize in a range of different audits, but the Bloomberg audit is one of my favorites because it's, the one that, what's the expression, a hand in a cookie jar. The attorney is very excited when they see all of this data that gives them the ammunition to win their case. We are one of the top auditing companies in the state of New Jersey. Probably one of the top 5 companies nationwide that produce these audits. We are NAMU certified, and we are also bank foreclosure examiners. We're going to be doing, actually, in conjunction with Mr. Opel, which is one of the attorneys that we have in our network, who's licensed in New York and New Jersey. He's normally the lead attorney filing the quiet title actions in federal court. And we also have Carl Pearson that work in conjunction with us as co-counsel. We will be doing a seminar the 22nd of this month. For more information, you can call 973-471-3381 and reserve your seat for the quiet title action seminar. It's for attorneys, it's for homeowners, realtors, anyone who want information about fighting back, suing the bank, and bringing a quiet title action to stop the lender fraud. And that's typically it. If you want more information on the Bloomberg audit and what it looks like and what it entails, you can go to our website at primelegalsvc.com and go to the sample audit tab and click on the securitization audit, and you will see the comprehensive detail report there. The Bloomberg audit also comes with an affidavit. Whichever auditor completes the Bloomberg audit signs an affidavit to their findings. The auditors are usually certified as Bloomberg, has the Bloomberg certification, as well as the Security and Exchange certification, and navigate these informational portals to extract the information the attorneys need to successfully win their case. Once again, the website is primelegalsvc.com. The phone number to reserve your seat for the quiet title seminar is 973-471-3381.
Hi, I'm William P. Opel, principal member of the law offices of William P. Opel. I'm a referral attorney for Prime Legal Services. Basically, my role in conjunction with Prime Legal is that I take referrals of their clients who have issues regarding foreclosure and other mortgage litigation issues, and defend them in New Jersey Superior Court for foreclosure defense or for quiet title actions in New York Supreme Court. I also handle other associated real estate matters such as short sales and deeds in lieu of foreclosure. With regard to quiet title, I'm going to go over the process of advising clients, the role the audit plays in our determination of whether to proceed with a quiet title action, and basically our procedure for handling a quiet title action in New York Supreme Court. We begin the process by meeting with the client, advising them of all of their options. With regards to the quiet title procedure, we let them know that we're able to work out a restructured mortgage for them, or we can go forward with litigation, depending on what their mortgage documents tell us. We sit down with the clients, we do an initial document review. At that point, we're able to get a pretty good understanding of whether or not a quiet title action is appropriate. Usually, as far as timing, if the client is on time with their payment or anywhere in the prejudgment area, that's what we feel is a good time to proceed with a quiet title action. Anything post-judgment is a little bit late to proceed with this, so what we would generally do is at that point focus more on the foreclosure defense before initiating any kind of quiet title action, because we want to make sure that, because the quiet title action, as in any litigation, would take a few months, we want to make sure that, the client is not going to have their house sold in the midst of a quiet title litigation. Basically, as far as the client's feelings, if they do not want a restructured mortgage, if they're interested in working something out with the bank, and their main focus is on principal reduction, then we would begin our quiet title litigation process. At this point, we would order an audit of the mortgage. I'd review the audit to make sure that the loan was securitized, how it was securitized, what the chain of title looks like, and if there's issues with the chain of title, then I would see that the client's mortgage is a good candidate for a quiet title action. At that point, let me backtrack a little bit. If we determine at that point that the client doesn't have a good case for quiet title, then we simply won't file it. It's too expensive to go forward with something like that. So what we would do then is we'd discuss it with the client, of course, but we'd recommend going forward with some kind of mortgage restructure where we would work out some kind of settlement, reduced monthly payment with the bank, so that the client is able to stay in the home if they desire to. But if we're going to proceed with quiet title, we would send out the qualified written request, as I'll refer to it, QWR. This is a statutory document. It's allowed under RESPA, and basically it's an initial request of the servicer to provide any information relating to the servicing of the loan, payment information, loan information, and the servicer is required to not only confirm their receipt of this letter within 20 days, but also respond to your inquiries as they're required in 60 days. The QWR, a lot of times from past experience, we see that when we send out, we'll make 25 requests of the servicer. Not all of them are adhered to. The servicer only has to answer service-related questions, pretty much payment-related questions, fee-related questions. They don't really have to, they're not required by law to answer anything relating to the note being held in trust, any issues with trustees or nominees or anything along those lines. Their requirements are basically servicer-related. At that point, after receiving 60 days later, after receiving the response to the QWR, we'll be able to determine what course we're going to take in the quiet title litigation. Again, we'll reassess the case, make sure that the client has a case to make against the servicer and the holder of the note in a quiet title action, and we will send out a first settlement letter if we determine that it is an appropriate lawsuit. The settlement letter will request a significant reduction in principal, and it will also request a fixed interest rate and affordable monthly payments. If we don't receive a response from that, a response to that settlement letter, at that point we will initiate litigation and file a complaint in the Supreme Court of New York, the trial court in the state of New York. The reason for this is basically most of the notes that are held in trust are held in New York-based trust, first off, but also when a note is held in trust, it's governed by a pooling and servicing agreement, and under those pooling and servicing agreements, the majority of them are governed by New York trust law and require litigation to begin in New York. The goal of any quiet title action is to quiet the title. It's basically to make sure that the homeowner, if there's issues with the chain of title, that the homeowner is free and clear from any action on behalf of the servicer or owner of the note or trustee who is not a rightful entity to foreclose on the homeowner. Our goal, apart from that, would also to make sure that if we were going to agree to any form of settlement or anything apart from the mortgage free and clear, we would negotiate to ensure that there's no deficiency judgment. Basically, that if a settlement was worked out, it would be a settlement in full, and nothing more would be owed to the bank. And we would also seek to have some form of cash settlement too to cover the fees associated with litigation for the client. That's basically, in brief, our litigation model for quiet title actions. We don't intend to file for any frivolous litigation because we're not going to subject ourselves to any sanctions. If the client has a case, we continually reassess that throughout the course of our contact with them, and are able to make a determination after reviewing the audit, after reviewing responses to the QWR, and after reviewing responses to the settlement letter, whether or not litigation is appropriate. If it is, then we have this established course of action. We file the complaint and we take it from there. Thanks for viewing the webinar. Again, my name is William P. Opel. If you have any questions, feel free to contact me. My phone number is 973-771-3967, and I can also be reached at WOPEL, O-P-E-L, at opellawoffices.com. Thank you.
That concludes the Quiet Title webinar. We're going to open up the floor to some of the questions that were posted now.